Madam Secretary, please call the roll.
Chairman Trent. Senators Gregory, Bernstetter, Carter, Coleman, McCreary, Weber.
We have a quorum.
Mr. Chairman, I'd like to seek unanimous consent of the committee to wear denim today. Today is Sexual Assault Survivor Awareness Day, and there was a case in the 80s where a man was let off of a conviction for sexual assault because the woman he alleged was wearing such tight jeans he couldn't help himself. And so today is Denim Day in honor of that. And so if any senator has a problem with that, I have a change of clothes in my office and I'll excuse myself, but if not, I'd like leave to wear jeans today.
Hearing no objection. All right, I make a motion that I make a motion that we go into executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Aye. Any to the contrary? The ayes appear to have it. The ayes do have it. We are now in executive session. I first make a motion that we bring House Bill 2146 before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any contrary? The ayes appear to have it. The ayes do have it. The bill is before the committee. There is a Senate committee substitute. It has been distributed, ending in .03C, and I move for its adoption. The only difference between this Senate committee substitute and the underlying bill is that it adds language for the 340B drugs in Section 376.417. And this is a provision that has, I believe, been voted out of committee before and has been on the floor before, but has not passed out of the Senate this year, I don't believe. But just giving it one more chance. Any discussion on the motion to adopt Senate committee substitute? Senator, please proceed.
So when you say it has 340B language in it, is it helpful 340B language or controversial 340B language?
Well, those two things could be the same, but yes, I believe this would expand protection or expand access to the 340B program.
Okay, thank you.
Yeah. Mm-hmm. Yeah. Further discussion on the motion to adopt Senate committee substitute? Hearing none. All those in favor of adopting Senate committee substitute, please signify by saying aye. Aye. Any to the contrary? The ayes appear to have it. The ayes do have it. You've adopted the Senate committee substitute. I next make a motion that the committee vote to pass Senate committee substitute for House Bill 2146. Do I have a second? It's been seconded. Any discussion on the motion? Hearing none, I renew my motion that committee vote do pass Senate committee substitute for House Bill 2146. Madam Secretary, please call the roll.
Chairman Trent. Aye. Senators Gregory, Bernstetter, Carter, Coleman, McCreary, Weber.
By your vote of 5 ayes and 0 noes, you have voted to pass Senate committee substitute House Bill 2146. I next make a motion that we bring before the committee House Bill 1399. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Aye. Any to the contrary? The ayes appear to have it. The ayes do have it. The bill is before the committee. I next make a motion that the committee vote do pass House Bill 1399. Do I have a second? It's been seconded. If everyone recall, this is the bill that establishes the Unemployment Administration Adjustment Fund. Any discussion on the motion? And I'll give folks in the front a little bit of time if you're looking through your notes. All right, hearing no discussion, I renew my motion that the committee vote do pass House Bill 1399. Madam Secretary, please call the roll.
Find it? No, okay.
Senators Trent, Gregory, Bernstetter, Carter, Coleman, McCreary, Weber.
By your vote of 5 ayes and 0 noes, you have voted do pass House Bill 1399. I next make a motion that we leave executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Aye. Any contrary? The ayes appear to have it. The ayes do have it. We have exited executive session. We will now proceed to public hearing for House Bill 2517. Representative Brown, please proceed when ready.
Chairman Trent, committee members, thank you for time and opportunity to present House Bill 2517 this morning. For the record, I am Chris Brown, House District 16, which is in the northland of Kansas City. House Bill 2517 relates to the practice of real estate wholesaling. House Bill 2517 would require that a real estate wholesaler, prior to entering into a purchase agreement with a property owner, must provide to the property owner a written disclosure statement. This disclosure statement would advise the seller to seek legal advice prior to entering into a contract with the wholesaler, and that the wholesaler is not working on the seller's behalf or representing the owner in the transaction. I don't feel a terrible need to belabor the bill's explanation, as this is the exact language as Senate Bill 973, sponsored by Chairman Trent, to which the Senate has previously heard and passed. However, this bill, 2517, did pass off the House floor 130 to 6. With that, I'd be happy to take any questions.
Questions for the bill sponsor? We appear to have answered our own question.
That's a positive.
Yes, indeed. Hearing no questions from the committee. First witness testifying in support.
Thank you, Mr. Chairman, members of the committee. My name is Jason Zamkus. I'm a registered lobbyist representing the Missouri Association of Realtors. This bill has been narrowly tailored to preserve legitimate wholesaling activities while putting in place consumer protection safeguards, as well as enforcement mechanisms to root out bad actors and stop them. For that reason, we'd like to go on record in support, and I'm happy to answer any questions.
Questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support.
Good morning, Mr. Chairman, members of the committee. My name is Arne C. A.C. Dino, State Public Advocate. I submitted my online testimony on the Senate portal. Did you receive it? Cool. Thank you so much. This is a no-brain piece of legislation. It's only fairness when a retail wholesaler buys a bulk amount of properties that they make the proper disclosures to the potential buyers. On February 3rd, I testified before the Economic Development Committee in favor of HCS, or at that time, HB2517. I've also testified, I believe, on behalf of Senate Bill 973. This is a no-brain piece of legislation. Let's get over the finish line and onto the governor's desk. It's a good consumer protection bill, and I think it's the right thing to do on behalf of 6.2 million Missourians. Therefore, I highly support HCS HB2517. Thank you, Mr. Chairman.
Questions for this witness from the committee? Hearing none. Next witness in support. Seeing none. First witness in opposition. Seeing none. Any witnesses here for informational purposes only? Seeing none. Representative, do you have any concluding remarks?
I do not. Thank you for your time.
Thank you. That will conclude the public hearing on House Bill 2517. We'll next proceed to public hearing for House Bill 2927. Perhaps our presenter is not here yet. Okay. All right. We will actually move that one to the last position here today, and we will next go to House Committee Substitute for House Bill 2711. Representative, please proceed when ready.
Thank you, Mr. Chairman, Senators, members of the committee. For the record, Dane Deal, serving Bates, Vernon, and Cedar County, District 125, here to present House Bill 2711. House Bill 2711 reduces the assessment rate for broadband equipment from 33% down to 12%, more aligns with the states around us, really focused from where I'm from, the low return on investment areas in Missouri, and getting closer to that complete build out across the state. Focuses on new equipment. It's definitive. I think that Senator Hudson also has that bill on this side of the building. It was worked on yesterday. We're still committed to working through that process, trying to make it a better product. A few things changed from the House side, and through this process we learned it's not just rule specific. There's areas across the state that continue, urban and suburban, that need the final push to get broadband done across Missouri, and I think this bill addresses that and more aligns us with the states around us. So with that, take any questions.
Questions for the bill sponsor? Hearing none. First witness in support.
Committee, I am Jeremy Ketter, and I'm here on behalf of AT&T Missouri. Thank you for this opportunity to testify on House Bill 2711. House Bill 2711 establishes clear, consistent, and predictable tax treatment for broadband communications equipment for telecommunications providers making long-term capital-intensive investments in fiber and network infrastructure. That predictability is essential. Our company spends hundreds of millions of dollars in Missouri each year deploying and maintaining broadband networks to keep Missourians connected and our state competitive. Lowering the assessment ratios also helps maximize private investment. Every dollar saved can be reinvested into fiber deployment, cell sites, network upgrades, creating local jobs for contractors, engineers, and other skilled workers. Last year, we announced that because of the new federal tax changes in the One Big Beautiful Bill, AT&T expects to invest more rapidly in next-generation networks, increasing our investment by an additional 1 million fiber customer locations annually starting this year. House Bill 2711 follows that same proven model. Sound public policy, including tax relief, and translates directly into infrastructure investment. We respectfully urge your support. Thank you.
Questions for this witness from the committee? Hearing none.
Thank you.
Next witness in support.
Thank you, Mr. Chairman. For the record, Noel Torpy with MCTA. Want to go on record in support. Want to thank the sponsor. I know there was a lot of debate over this language yesterday in this chamber. You know, a lot of talk about BEAD money. Keep in mind, I mean, when we're trying to get to those final 200,000 households in Missouri, the BEAD money is kind of filling in that gap, right? I mean, sometimes it'll cost $15,000 to get to that house. Our companies pay $3,000. The BEAD money backfills that to make it even and worth it. Under the Trump administration, they kind of shrank that threshold on how much money you can spend to get to households with fiber. And so that was talked about a little bit, but a piece of legislation like this encourages us to get all over and to truly reach those 200,000 households over the next 4 years. I mean, there's a 5-year sunset. And we would encourage you all to pass this piece of legislation to try and get broadband out to Missourians quicker. I'd be happy to answer any questions.
Questions for this witness? Hearing none. Next witness in support.
Mr. Chairman, members of the committee, Bill Gamble, registered lobbyist, appearing on behalf of the Missouri Broadband Providers Association, formerly known as the Missouri Small Telephone Company Group. We're in all parts of the state, down in your area. We are in really the most rural, low population density, high-cost areas. We have built out in our territories, and now we have been asked and been working with the state and others to build out further into areas that don't have broadband service. It's very expensive to do that last mile. If you're getting to that, you can go to the road, but going up the lane to the farmhouse is an additional cost. This would help us do that. All our companies are either family-owned, very small corporations, or cooperatives, telephone cooperatives. So we're committed to do this, but this would be very helpful in the whole picture to make us provide economical broadband to people, because it's also got to factor in the fact we've got to make sure that this is affordable, and this allows us to make broadband service more affordable. And I'll just close by saying something I've never said before. I agreed with almost all of Noel Torpy's testimony. Yeah, I know. That was.
I think that created a question. Please proceed.
Did I hear you say, Mr. Gamble, that you agree with Mr. Torpy?
With Mr. Torpy?
Yes.
Yeah, I agreed with his testimony.
Thank you.
Yeah, that's a first. Yeah, I know. I ended in a bang, right?
Any further questions for the witness? Hearing none.
Thank you.
Additional witnesses in support.
Mr. Chairman, members of the committee, I'm Mike Sutherland, Vice President of the Missouri Electric Cooperatives. We have 17 of our electric cooperatives that have subsidiaries that deploy broadband in rural parts of Missouri. I agree with the testimony that's come before. I won't reiterate that, but we do support this legislation and hope that you will act on it.
Questions for this witness? Hearing none. Further witnesses in support.
Morning, Mr. Chairman, members of the committee. Ray McCarty, President of Associated Industries of Missouri. I want to go on record in support of this. As the broadband is rolling out, the prices are going down and the speed is going up, and that's helpful to businesses across the state, so it's worth it to reinvest some of this money. Happy to answer any questions.
Questions for this witness? Hearing none. Next witness in support. Seeing none, witnesses in opposition.
Thank you, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. I submitted my opposition online on the Senate portal. Appreciate you acknowledging that. I'm opposed to HB 2711 on February 4th before the House Utilities Committee. I also opposed this bill. Reducing broadband personal business property tax by 2/3 is just reckless, especially when we're facing a $2 billion deficit budget, $1 billion in fiscal year 2027, $1 billion in 2028, and that's backed up by a memo that each one of you received in December. And we need to take it seriously before we're into deficit spending, before our credit rating starts to go up and our bond rating increases for road projects and major capital improvements in terms of bondability. I believe that Missouri broadband bill, that this bill and companies, they're not going to reduce the bills to customers by $28 million. The fiscal note states that there will be a reduction of $28 million to local government, and that's wrong, especially in this economy, especially with unknown sales tax income, and especially with the abolishment of income taxes. That won't affect local government, but sales taxes will, and also personal and real estate taxes do in terms of school districts, education, fire districts, ambulance districts. I could just go on and on, the litany. As a matter of fact, we're in the top tier of political subdivisions across our nation. The fiscal note states that there will be a $28 million loss to local governments and special districts. And what's really concerning is we keep, in many bills that are before the legislature and before the state senate, we keep picking on the blind pension fund, which is administered by the state of Missouri. Again, this fund will take another $42,000 hit on the backs of people who need help to survive and to sustain themselves. And I would ask that some type of amendment be made to make sure that the blind pension fund is not affected. In my opinion, this bill is clearly picking winners and losers. It's clearly driven by the six-figure lobbyist who appeared before me in support of this bill and who brought this bill to the House sponsor. It's about time that this legislature stand up to special interests and put Missourians first and foremost. It's about 6.2 million Missourians, not about profitabilities for huge conglomerate corporations, that they're going to take this $28 million and they're going to divide it to their stockholders. They're going to give extra bonuses to their executives and extra bonuses and commissions to the executives and directors of their departments. The consumer will not see one iota, not $1, of reduced bills on their broadband or internet services. For those reasons, there's no way I can morally, ethically, or intelligently support HB 2711, since it's definitely driven by special interest. Thank you, Mr. Chairman.
Questions for this witness from the committee? Hearing none. Further witnesses in opposition? Seeing none. Any witnesses here for informational purposes only? Seeing none. Representative, did you have any concluding remarks?
Yes, thank you to the committee for hearing this bill. I have lived it. I had satellite internet, faced the challenges that many Missourians have faced. I just finally was able to get streaming services about a year and a half ago through the stem of investment. And I think the merits of this bill to try to continue that investment are valid. I do think that there's a couple states around us that are completely exempt, and this just clarifies new equipment on that build out moving forward for a time frame to get that completed across Missouri. So thank you to the committee.
Thank you for that presentation. That will conclude public hearing on House Committee Substitute House Bill 2711. And with the committee's indulgence, I think we wanted to get this bill out to the floor as quickly as possible, so I'll make a motion that we go into executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any contrary? The ayes appear to have it. The ayes do have it. We are in executive session. Next, make a motion that the committee vote do pass House Committee Substitute House Bill 2711. Do I have a second? It's been seconded. As everyone will recall, you don't even have to recall. This is the bill that we just heard. Any discussion on the motion to vote do pass? Yes, Senator, please proceed.
I feel like I have to say this every time, but I generally am uncomfortable hearing a bill and voting on it the same day, even though we spent a lot of time on this subject yesterday. I do think because we spent so much time on this yesterday in another bill, that it's an indication that the language is going to need to be tweaked if it's going to go anywhere. So just wanted to add that. Thank you.
Yes, thank you for that, Senator. Yes, I think that's probably an accurate sentiment. And of course, given how close we are to the end of session, I too share your sentiment many times about voting things out the same day. But I think if this is to have any chance to be further refined, that it's warranted. Further discussion? Hearing none, I renew my motion that committee vote do pass House Committee Substitute House Bill 2711. Madam Secretary, please call the roll.
Chairman Trent. Aye. Senators Gregory. Aye. Bernstetter. Aye. Carter. Coleman. McCreary. And Weber.
By your vote of 6 aye and 1 no, you have voted do pass House Committee Substitute House Bill 2711. And I make a motion that we exit executive session. It's been seconded. All those in favor, please signify by saying aye. Any to the contrary? The ayes appear to have it. The ayes do have it. We have exited executive session, and we will proceed to public hearing for House Committee Substitute House Bill 2035 and 2350, Representative, please come forward and proceed when ready.
Good morning, Mr. Chair and committee. My name is Jeff Farnan. I represent District 1, which is Northwest Missouri. Today I'm here to present House Bill 2035. This bill updates Missouri's law to address AI-generated content, particularly around sexually material and mental health services. First, no one can use an AI depiction to use a real person's face, body, or voice without their written consent. Victims may now sue for damages and attorney's fees. This also modifies our existing child pornography laws to include AI-generated material. This means it is illegal to generate AI images that look like minors in sexual situations, even if no child was involved in making them. And then finally, companies and developers cannot advertise or claim that their AI can act as a therapist, provide counseling, or diagnose mental health conditions. And with that, I'd be happy to take any questions.
Questions for the bill sponsor? Hearing none. First witness in support.
Thank you, Mr. Chairman, members of the committee, Arnie C. A.C. Dino, State Public Advocate. I submitted my online testimony on the Senate portal. Thumbs up on that you received it. I'm in high favor of HCS HB2035 and HB2050. You know, when it comes to mental health, I think that there needs to be a professional counselor that somebody can see directly if they're doing online counseling. With AI, I think that there's so many fraudsters, so many scams out there. As a matter of fact, I believe there's a House member that proved that in terms of text messaging last year involving a crisis counseling institute or crisis counseling organization here in Missouri that receives public funds from the State General Assembly. And I believe that there was AI generation or AI responses from a computer. We need to make sure when people are having a health crisis or a mental health breakdown that they're actually talking to a mental health professional. When it comes to the sexual conduct or sexual content, using somebody's image, I think that they should be punished severely. And I think that some image could ruin anybody on the dais or anybody in the audience. They could ruin your life or your family life in a mere instant of somebody who is aiming you as a public official. And I think that those people need to be held accountable, held to a standard of responsibility and accountability. It seems like we have to keep getting ahead of the ball game, and we're catching up constantly. Law enforcement needs these tools to investigate, and prosecutors need these bills to adequately prosecute them and hold people accountable and responsible. In my opinion, this is a must bill that needs to get on the governor's desk as soon as possible. This is common sense legislation. We must protect each and every Missourian with this AI generation, and there shouldn't be any arguments. It should be a non-partisan bill. Let's get this on the governor's desk. Therefore, I support both of the House bills. Thank you, Mr. Chairman.
Questions for this witness from the committee? Hearing none. Next witness in support.
Chair, members of the committee, Jessica Petrie-Telemock here for the National Association of Social Workers Missouri chapter. We specifically want to support the provision of this bill on mental health professionals' title protection, which is identical to Senate Bill 1444 that you all heard earlier this session from Senator Lewis. This isn't trying to regulate the operations of AI models, but is trying to get at how they advertise and represent themselves to consumers. We have consumer protection and title protection laws around the way humans can describe themselves if they can't pretend to be a mental health professional, and we believe that same logic should extend to AI models, so people know what they're getting into and can make an informed decision. So appreciate your consideration and happy to take any questions.
Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Thank you, Chairman and Committee. Kurt Wickmer, representing the Missouri Catholic Conference, testifying in support. The Catholic Church is opposed to pornography on moral grounds, and in particular opposed to child pornography because it victimizes the most vulnerable people in our society, our children. Even AI-generated pornographic images of minors are still abusive because the way AI generates images, it bases it off of existing images. Therefore, it bases it off of existing images of victimized children. We want to do what we can to limit the ability for people to produce this kind of pornographic content, and for that reason, we support.
Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support. Seeing none, witnesses here testify in opposition. Seeing none, witnesses here testify for informational purposes only. Seeing none, Representative, do you have any closing remarks?
I don't. I think my witnesses said it all. Thank you.
Thank you. That will conclude public hearing on House Committee Substitute House Bill 2035 and 2350. We'll next proceed to public hearing for House Committee Substitute House Bill 2481. Representative, please proceed when ready.
Hello, Representative Jamie Ray Gragg from the House District 140, Christian County, here to present House Bill 2481. This is basically some language to basically put us in line with the federal government when it comes to a federal program, SNAP benefits and benefits across the state when it comes to items that we get from the federal government, when it comes to dollars that bleed from the federal government down to the state that we distribute. When it comes to the dollars that we get for SNAP, of course, we've been working with a waiver program that the governor applied for last year. That, of course, went through. We did get that waiver in December. So that was something this will be able to basically put in statute and everything. So this also has some language that was put in for other programs that we've got in the state when it comes to other programs. When it comes to folks that are here in the country with their citizenship, it works to make sure that when people are applying for benefits that they are complying with their citizenship requirements, making sure that if they are working towards citizenship, that they are working towards that when they are applying for benefits. So make sure that they are doing the proper paperwork and doing the proper work to get the benefits. If there are any questions, I will answer.
Questions for the bill sponsor? Yes, Senator, proceed.
Thank you, Representative. What were the parameters of the waiver that the state received this past year?
I'm sorry, say that again, please.
What were the parameters of the waiver that was received?
The parameters that we received, as in like the...
You said we're codifying the waiver requirements. What were those specifically?
The language, in which case the food and the beverage, correct?
I don't know. I'm asking.
Correct, yes. So the Missouri specific information for restriction items, it talks about excluded items for the waiver and then excluded beverages. Specifically, excluded foods are candy and prepared desserts, and then there are excluded beverages. And it lists them out in definition from the federal government. I do have an amendment that if the committee does choose to pass this on, that we can put that as an amendment, so the exact language that the waiver that did come from the federal government, we can make sure the exact language does get placed in this as well.
And that definition is mirroring the SNAP waiver
The SNAP waiver that did,
application from the Kehoe administration that was adopted.
this is actually, the waiver that was applied from the Kehoe administration was sent to the federal government. Then the actual waiver itself that did come from the federal government, I have a copy of that in my file here, and the exact language we can actually plug straight into this as well. So we have the exact language that did come from the federal government mirrors.
Okay. Do you have any concern that adding additional requirements at this time and statute would increase our error rates?
Our error rates?
Are you familiar with the new requirements by the feds about the error rates for various social benefit programs?
I think this actually puts checks and balances in, because I know right now we've got the checks would be for, of course, checking with the computer systems, but this also says that if they come in and they apply, and every time they have to reapply, they have to, of course, show their paperwork. So that actually would be a checks and then a balances. So I think that would actually keep us from having errors.
Okay, maybe you'll have an expert witness who would be able to better answer that question. Thank you, Representative.
Thank you.
Further questions for the bill sponsor? Yes, Senator, proceed.
More of a comment based on the inquiry. I would be uncomfortable putting anything in statute that mirrors the federal language, because I think when there's a change in administration that all of that would be reversed, and then we would have contradictory information in state law. So I would be opposed to doing that. Thanks.
Further questions from the committee? Hearing none. First witness in support.
Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. I submitted my online testimony on the Senate portal. Thank you. On February 25th of this year, before the House Standing Committee on General Laws, I supported this bill. There was a lot of discussion. I encourage all of you to view the video that's online on the House archive. This deals with SNAP benefits. I'm a believer that you need to be an American citizen to qualify for the program. There are a litany of organizations that assist immigrants that are moving to Missouri from other countries, either to seek sovereign immunity or to escape their country's ongoing wars. So there are many organizations that help out with lodging, help out with food, nutrition, medical issues. When it comes to candy and sugars, I believe that is not the basis of the nutritious program offered by the federal government. Nutritious and the basics intention of the program are to provide basic food and wholesome foods. Fresh fruits, fresh vegetables, which were talked about in the bill, trying to home in and buy products from Missouri farms, Missouri raised beef, Missouri meat farms, poultry, and a litany of other businesses. We are a leading agricultural state among our 50 states, and therefore I think we should provide our own right here in Missouri with the benefits. The bill speaks for itself. It's not asking for a lot. It's asking for mere basics, doing the right thing, making sure, cutting down on frauds and misuse of the monies. I'll tell you what irritates me more than anything is to be in line at Schnucks, Deerbergs, or other grocery stores and watching people sell their card as a commodity, and there's a trading going on where that person holds the card, somebody behind them in line, I don't know if they're related to them or another party, ends up purchasing other foods, and that is wrong. It needs to go to the people who it's intended for. It's not to be a lifelong gift or a welfare type recipient item. It is something to sustain them until they can get on their feet. It's a hand up, and people have to take the boots by their straps, take responsibility, and try to get off of the program so others can utilize it to avail them and get them out of their need. So therefore, I support HB 2481. Thank you, Mr. Chairman.
Questions for this witness? Proceed.
Are you aware that the activity you just described is already illegal?
Can you speak up? I can't hear you.
Are
I'm
you
sorry.
aware that the activity you just described is illegal already and that this bill doesn't address any of that activity?
I agree with you with that statement. I just was saying
So
that.
I just want to caveat and say, like, you know, you testify a lot, and I really love it when you do, and I appreciate your work. But
Right.
when your comments don't match what the bill is proposing, it lessens the seriousness with which we can take your testimony. And so wanting everybody to be a citizen, totally reasonable, the bill addresses it. But talking about other illegal activity that isn't addressed in this bill makes it hard for people to pay attention to you when you're testifying. So that's it. I'm not picking a fight with you. I just am saying, Arnie, like, that's illegal already.
I just was pointing out an irritation that I see constantly.
I know,
that's
but you know
with the
what?
program.
Somebody I know has a hate list in their phone, and every time something annoys them, they add it to the list. Like, just put it in your list and move on. Like, it doesn't have to do with anything on this bill.
Duly noted.
Thanks.
Further questions? Hearing none. Next witness to testify in support.
Good afternoon, almost good afternoon, Mr. Chairman, members of the committee. For the record, James Harris representing FGA Action to testify in support of 2481. I think the two pieces, the SNAP candy and junk food is, I think, kind of a part of a broader discussion. You know, when you have nearly 20% of a benefit being used for things that are unhealthy, it's commendable the governor applied for this waiver and it was approved, but trying hopefully to have more of a longer discussion about healthier food, education. I mean, there's a lot of other things I think we could all agree on that would be good if we could do, and this is a piece. The second portion is really kind of to have Missouri mirror H.R. 1 as it relates to non-citizens' eligibility to participate in the Medicaid and the SNAP program. And this, I think, is important for, as Missouri has to grapple with its Medicaid fraud rates. I know DSS will be implementing technology, at least according to the budget, hopefully to help with eligibility checks and making sure people are eligible for these programs, but just to have a little more wording to help with that effort. Happy to answer any questions.
Questions for this witness? Yes, proceed.
I have questions specifically on page 4, lines 94 through 101. It talks about an application applying for benefits with minor children shall be required to provide documentary proof of relationship to the child or proof of financial responsibility. It goes on to say that if the applicant isn't eligible, but the benefits for the children, they shall be administered for the children only. How do you propose somebody makes dinner and doesn't feed themselves but feeds their children?
That is a great question, Senator, and I don't have an answer on that.
Okay, so let's work through that. I think that I understand the intent of wanting to make sure taxpayers receive taxpayer benefits, but our social safety net program should be there to support our children. And right now, the way that this is written is totally unworkable for the realities of how that would happen.
Absolutely, Senator.
Thank you.
Further questions for the witness? Hearing none. Next witness testify in support. Seeing none, witnesses here testify in opposition.
Good morning, Mr. Chairman, members of the committee. My name is Jeff Smith. I'm testifying on behalf of the American Civil Liberties Union of Missouri. We understand the interest in verifying eligibility for public benefits. We appreciate the sponsor's interest in doing so in his work. And I appreciate personally his willingness to meet with me to discuss some of our concerns and his willingness to work on some of them. However, there's one outlier provision in this bill that we have serious concerns with. I say it's an outlier because there are, I think, 22 other states that have similar legislation, but this would be the only one that we've found that has the specific provision that I'm about to discuss. And that provision states that if an agency is unable to determine an applicant's lawful presence after a SAVE query using the SAVE database, then the agency shall, not may, but shall, refer the case to DHS for enforcement action. We're concerned about that because it conflicts and in fact is directly in violation with the intended purpose of the federal SAVE verification system and federal rules that are intended to focus the use of that system on benefits eligibility verification and to prevent it from being used for immigration enforcement. And in fact, if enacted, that provision will create a backdoor reporting requirement that undercuts the rules Congress put into place in 1987 to safeguard against the potential misuse of SAVE. I'll read from that congressional prohibition from 1987 where they made it pretty explicit. Such system, referring to SAVE, shall not be used by the Immigration and Naturalization Service for administrative immigration enforcement purposes. So they were pretty clear, and what we fear about this language is that when reports come into DHS from Missouri, ICE could claim not to be bound by the congressional prohibition since the reports of unlawful presence would be coming in from a state agency instead of the SAVE database itself. So the existing limitation on the use of SAVE is important for a few specific reasons. First, again, the database is not designed to prove unlawful presence. The database is designed to verify status. So while the database can inform a benefits agency that a particular status claimed by an applicant has been verified or not verified, there is no SAVE response that specifically informs an agency that a person is unlawfully present in the United States. Second, in recent years, as states have attempted to use SAVE to verify citizenship claims on voter rolls, there have been significant findings of inaccuracy that have been documented, and I'd be happy to provide some of that documentation. It's certainly bad if a false positive leads to a family struggling to be able to put food on the table. I would argue it's even worse if a false positive leads to someone being wrongfully deported. Third, SAVE is highly prone to user error on top of that. It's designed to offer an immediate automated verification, but it's also seeks to perform further verification based on additional user inputs where the primary verification fails to offer a clear result. And traditionally, most agencies have found to rely solely on that first stage of automated verification, failing to follow through on additional input requests that would provide a fuller opportunity to verify an individual's claim of status. This isn't, don't take it from me, take it from the General Accounting Office of the United States, which found that, I quote, the majority of SAVE user agencies that received a SAVE response prompting them to institute additional verification did not complete the required additional steps to verify the benefit applicant's immigration status. We do not have sufficient controls to help ensure agencies are completing the necessary steps because of inconsistent guidance, and we lack reasonable assurance that SAVE user agencies have completed the necessary training explaining how to utilize the program correctly. So that remains the definitive study on SAVE. There's little indication that we've addressed this endemic problem of user error, and so if we do pass this with that provision, our concern is that by reporting some lawfully present individuals to DHS, Missouri would be inviting improper arrest and detention by an agency that doesn't have the best track record, especially over the last year or so. Again, I appreciate the sponsor's willingness to meet and discuss this, and hopefully we can address in particular this provision. Thank you.
Thank you for that testimony. I appreciate you highlighting how incredibly irresponsible the federal government has been, that they have no idea how to verify who is a citizen and who isn't, apparently, and apparently, within the nearest 10 million people don't know how many people are even in this country, unfortunately beyond the scope of this bill. Questions for the witness from the committee? Yes, proceed.
So my understanding is that you're saying the GAO is saying that states are failing to follow up on immigration status and that that's a significant problem with the success of the administration of the program. Is that too long didn't read version of what you just said?
Essentially. I mean, that agencies are they're receiving that automated kind of verification, and then they're not doing the next steps that they're being asked to as part of the training.
So I guess that's my concern, is that your testimony was then that you're wanting to say shall to a may, and what his bill's attempting to do is said, no, you have to then do a follow-up to verify if there's some kind of a kickback of the system. So I hear what you're saying, but I think that the conclusion is the opposite. We do actually want the agency then, if the system has a problem, to follow up and say like, hey, is that right or is that wrong?
I think, and maybe this is a little bit bears upon the chairman's comment, that there has been found over many, many years to be endemic user error. If we really believe that our state will be the outlier in training, implementation.
But this is my question though. So I think that what the bill is saying, and maybe I've misread the bill, is that they're saying if there is a positive, then the department shall verify whether that's true or not. And isn't that what we want? Because you're saying there's all these problems with the program. Don't we want the state to be required to take the next step to say like, hey, is this true or not?
I think our position is that certainly the state should be rigorous in its follow-up to ensure that when determining benefits eligibility, they should do that in accordance with the training on how the SAVE system should be used. We're also saying that the state should not take the further step of notifying DHS because of the documented problems over decades.
No, right. I totally agree with you, and I hear with that. My question is that page 3, line 76 through 79, all it says is a match through any electronic or data verification system shall not by itself be accepted as proof of identity, and every applicant for public benefits shall be required to provide documentary proof. And so what you're saying seems to support the provisions as written and not oppose them. That was my clarifying comment.
That provision that you're speaking of, we're not taking issue with.
Okay, it's another provision of it.
Yes.
Okay, thank you.
Thank you.
Further questions? Hearing none. Next witness in opposition.
Chair, members of the committee, Henry Telmark with the International Institute of St. Louis and the Jewish Vocational Services of Kansas City to go on record as in opposition to Representative Gragg's bill. So the biggest things that we take a little concern on, not a lot, a little, but some concern on in the bill is regarding, Senator McCurry, you had said this, regarding the federal language, right? So in H.R. 1, many of these provisions are already enacted. Right now, refugees and asylees who would have qualified for SNAP no longer qualify just based off H.R. 1 implementation time periods and will no longer receive these state benefits. But as Senator McCurry mentioned, that federal law changes or federal regulations change, and we will then be confined by state law, and now you're having a whole supremacy argument. Mr. Chair, Senator Coleman, you know better than I do how the supremacy clause will work in that aspect. And then the department will then have to figure out if they're going to follow state level guidance or federal level guidance. To answer a portion of what you had asked, Senator Coleman, on the SAVE Act. So the International Institute, we work with refugees and asylees who come to the country and place them in temporary housing, provide some kind of necessities in order for them to thrive later on, right? It's for a shortened time period, which is now 4 months based off H.R. 1 implementations once again. But what we have found, and this is not what the Department of Social Services has listed in this bill, it is based off of another department that for the verification of CDLs, they had to use the SAVE Act, the SAVE program. The SAVE program inaccurately placed those folks who came here legally, have been vetted, in the wrong domicile or habitat in which they're living, and the federal government, based off the reporting from, I believe it is DOR, had to investigate those fraudulent claims. So the departments do investigate, they do ask questions and query what is occurring. So the Department of Social Services right now, I'm not going to speak for them, I don't know if they use the SAVE program, but the SAVE program does have inaccuracies, and our concern is if you implement this right here, right now, those inaccuracies could potentially cause more errors later on, possibly putting Missouri at risk of the error programs that you had mentioned before.
Yeah, proceed.
Can I ask a quick question? So I think what you're saying is that the previous witness and what your organization seemed to be articulating a concern in is not the section that I was reading, but actually page 4, lines 102 to 106 in the reporting requirement, as though it were valid before there has been a verification that there isn't an error.
Well,
So page 4, 102 says, if verification confirms that an applicant enrollee is not lawfully present under those previous sections or any successor provision, the agency that administers that public benefit shall immediately terminate future benefits. So that's the concerning language, not that you then shall investigate, which is why I was a little bit confused. It's like, wait, we do want to force our agencies to investigate if the program is saying something, we need them to verify that.
Oh, yeah.
That's not what you guys are saying either. You're saying we need our agencies to be able to get the right answer, no matter what our third-party vendor says. And if there is a positive, we need to be able to investigate and confirm that before reporting it out.
Yeah, and they are investigating. So for licenses, they're investigating. Again, I don't know what DSS does with the SAVE program, but I'm not going to articulate on
I
that.
appreciate that. Thank you.
Of course.
Now, this has led to a question on my part here. So I understand in Section 12, you're worried that the SAVE Act or the SAVE program is going to give some kind of false positive. But why would Section 9 not act as a savings provision? Because the SAVE system is an electronic system, and it seems pretty clear that any match through an electronic or data verification system shall not by itself be accepted as proof of identity.
That's through.
Yeah, and that has crystallized it for me. I don't understand why Section 9 would not cure Section 12 of the deficiency that you're pointing out here.
So Section 9 most likely solves the verification aspect. But if the agency, because it says the agency shall verify the applicant through the SAVE program. So
sure.
Does it not then, again, this is where being an attorney in the legal mind works better than mine, right? Does it not conflict at that point in time?
Well, no, I mean, the way I read it, and of course, I could be wrong as well, but the way I read it is that you have to use the SAVE program. If the SAVE program returns a hit that the person may not be a citizen, that by itself is not enough to establish proof of identity. Then the agency is charged in subsection 2 with verification to confirm that the application or enrollee is not lawfully present in the United States or no longer qualifies, et cetera, et cetera. So to me, it's a multi-step process here that's being specified. I mean, if we think that process would not be sufficient or that this language does not require that process, then I think perhaps an edit is needed. But I think that's probably the core of the question that we're trying to get to here.
So again, we're always open to having.
But would you be comfortable if the process I just described was the process that occurred? There was a positive on the SAVE program, then the agency took additional steps outside that program to verify proof of identity, proof of citizenship, before taking any further action. Would that process be sufficient for your concerns?
So the big crux for us is the enshrining of federal law, and that's already handled on the federal level, saying, hey, we're going to tell how to administer federal dollars with state law. The crux of the SAVE Act, the SAVE program, our pieces were concerned about false positives and what could occur there. I don't want to speak on how the department would feel about that because, again, Senator, I do not know how the department would work on that program, so I would leave that up to them to either have backdoor conversations with you and answer that one.
Yeah. Okay. Thank you. I appreciate that. No problem. Further questions for this witness? Hearing none. Next witness in opposition.
Good afternoon. I'm Christine Woody. I'm with Empower Missouri. So before I go directly into my testimony, I do want to address a couple of the things that other folks have said to just kind of clarify them things. So for the Medicaid program, the Department of Social Services already runs everyone through the SAVE system. In their original budget that they proposed to you all that have now gone through the process, they have asked for millions of dollars to be able to do that SAVE system for everyone in the food stamp SNAP program. It is an electronic database, and while yes, there probably are some false positives, that is when the department already does then follow up and make sure that is the correct answer one way or the other. So they are already doing that in the Medicaid program. They are trying to implement that widespread in the SNAP program, and that was in the budget that you all passed for them. All of this is in response to the HR 1, so I want to put that out there. Another thing I do want to talk about that it was mentioned in the first couple presenters was about the Healthy SNAP, which is asking for those food restrictions for SNAP purchases. That did not pass this body last year. Because of that, the governor did submit an executive waiver to allow that to happen in the state of Missouri. The Department of Social Services is working through that process. It is an extensive process to implement something like that in the SNAP department because it has to go through the retailers, it has to go through the point of sale systems, it has to change all of the language and all of the scanners and all of that, and the department is working through that. They are meeting regularly with stakeholders about that process, trying to figure out definitions, trying to figure all of that out, and it seems like it would be not a very smart move to enshrine it in statute now while the department is already moving through the process and hopefully implementing that in the fall.
Can I ask a question?
Yeah.
Was there money that was in the budget to implement that program? I didn't see a line item for that. They're just absorbing those costs under their original operating expenses. So we don't have an estimate of what that will cost?
I do not, no.
Okay.
But it seems like we should not be enshrining that in statute now, just to let the department figure out that process and implement it. And then if there's something that we want to enshrine, we can do that. But it seems to be backwards to have the department do something, it be different in language, and then they wouldn't actually be able to go forward with what they were probably doing in the first place. So that's on that. The rest of my testimony is more on the verification, increased verification. This bill is framed in getting in line with federal law and preventing benefits from going to undocumented individuals. And in the reality is undocumented immigrants are not allowed to accept SNAP or Medicaid currently. And this would actually not bring us in line with federal law. It would contradict federal law, and as the department says numerous times in its fiscal note, we would face a loss of federal funding if we implemented the provisions in this law. First, so Missouri already requires verification of immigrant status for SNAP and Medicaid. You have to put a social security number or an A number, which is an alien verification number, on your application. If someone does not do that, they will not get either of these benefits. And in addition to that, they do run folks through the SAVE system as a double check. And if it comes up positive, they will do then further investigation to ensure that that's accurate. On line 76 on page 3 of the bill, this is what part I think that Senator Cohen was talking about. It says that these electronic verifications are not enough and would require documentary submission of every applicant, not only at time of initial application, but at recertification, and that is for SNAP households every 6 months.
May I jump in with a question? Okay, so right now, what is the retention policy for those high identity level of documents for the department?
That is the other challenge, is that there is to be a system that keep these documents private and secure.
Do we have that already? I know that we're really concerned about the error rate.
There is a system where they have to provide documentation, have to save those, but nothing like a birth certificate that has to be saved. So I think there would be a lot of additional technology that would have to be implemented to be able to keep secure over 600,000 birth certificates for SNAP applicants and over 1.3 million applicants for Medicaid.
Going back to the fiscal note, I also was kind of surprised at the 15, and I apologize. Sometimes you miss things as the budget process is going through. There has been a $15 million one-time application or funding that was put into the budget for extending the SAVE application through to the SNAP benefits recipients in the state of Missouri. But that's not even the end of it. What you're saying is that once we've spent that almost $16 million, well, no, I guess you'd round down, but $15.5 million, we would still need to have new additional programming and retention policies for those original documents to try to make sure that
and if you
identity
continue to
level
read in
stuff-
that fiscal note, the department actually says that having that additional verification goes against federal law, and we are not permitted to do that, and it would cost us financial federal dollars if we do implement that. They only allow one source of verification that must be required, and so if we add that additional verification,
second level.
we would be out of compliance.
And would that out of compliance rate be similar to our error rate and compliance problems where it's such a massive hit? I mean,
those are two separate numbers, but
okay, I don't know.
yes.
How do they calculate what that fine is for the state?
I don't know what they would calculate. I mean, I think if we are out of compliance on that level, that would be we would get no funding for SNAP. We would not be able to run the program.
Yeah, I mean, we hear that all the time, and I always find that to be a little unbelievable that they're going to not let Missourians go hungry. They're going to say, sorry, no food for you guys because there's this problem with the verification system. It seems that the federal government is more serious when they have those error rate, sort of like statutory, these are the hits you're going to hit, rather than just saying like, no, you're not going to get anything.
Yeah.
So, okay, I'm sorry I keep interrupting
That's
you.
okay.
I just don't want you to move on to the next thing and then me miss the question that I had
No,
on the
that's okay.
previous thing.
Please proceed.
Food, we're talking about food. Like, I'm not willing to play a game of chicken with the federal government to risk not having that assistance either. So in my opinion, this fiscal note and this bill are just a non-starter as far as I'm concerned. So thank you. If you can keep going, Christine.
Yeah, the other point that I want to point out is also something that Senator Coleman mentioned. It's in page 4, line 94. That is where it says that FSD is required to verify adult applicants' relationship and financial responsibility for each child in their household. So under SNAP law, neither proof of relationship nor financial responsibility are required for a minor to be included in a SNAP household. So citizenship status is required to be verified. They also run everyone through their system to make sure that a child is not on more than one SNAP household, but being able to verify your relationship to the child or the financial responsibility is not required. So for example, if there's a grandparent who is watching the grandchildren because the mom and dad are no longer in the picture, that person does not have to show their tax documents that they're claiming that child or any of that. They can just add that child to their SNAP household, and that is also a requirement in the SNAP policy. So if we implemented that provision, again, we would be out of compliance and we would be lost of federal funding for that. So those are just two examples. I don't want to belabor this, but we have a lot of other details, a lot of federal regulations, and a lot of data that shows that the language in this bill would be impermissible. It would cost millions of dollars. It would cost at least an additional 42 full-time employees. That's not including the number of employees if we do not pass that money in the budget regarding the SAVE Act. That would include another 200-plus employees. So those are for the reasons that I believe this bill should not pass through this committee and should not pass this chamber. Thank you. I will take any other questions.
Further questions? Proceed, Senator. Yes.
Thank you for being here. I have known you for a very long time. You've kind of worked, how long have you worked in like this food security
I'm
area?
celebrating my 20th anniversary with Empower Missouri this year.
That doesn't seem possible, but I thank you for everything you do for the state of Missouri. I
It's a
really
long time,
appreciate
yes.
it. Yeah, I wish all the witnesses had your level of experience on this. So I wanted to, could you just give the committee an example of a situation, like you talked about a grandparent maybe, and the parents just split, but there also are other situations where a home can just be the safe home in a neighborhood for a kid that's really struggling. So, I mean, is that
Yeah,
something?
I mean, the way that the SNAP household works, the way that they calculate a household is people who are living in the same house who purchase food and share food together. So it can even be two adult roommates. If they are living in one house and they share food and they cook together, that's considered a household. So you can't even have two SNAP cases if you live in the same house and you share food. So that's really how they calculate it, that if you are living together in a household, purchasing food together, cooking food together, that is considered a household.
I mean, I just think back to growing up there were kids that just sort of moved into somebody else's house because their home situation was so bad, and just because they're not related to that child,
Yes.
they're still living there to get away from abuse and neglect and that kind
but
of thing.
on that front, I mean, there is an extensive application process,
Yeah, of
right? So you
course.
have to have your social security number, you have to have all these details, and so the department can tell if that child that's now living on the couch of their neighbor is also in another household and being counted. So you can't be on 5 households
Right,
of SNAP,
right.
right?
But
you
it
can take that person
recognizes-
in and you can help them out, but they also can't be helped out by the neighbor and their grandparent and their parents.
Right.
It really is calculated and targeted of who it is, but also it does allow for some flexibility.
It allows for flexibility because we know life is not, things aren't always black and white and like clean. So, all right. So I've spent a ton of time with your organization trying to understand things. I'm really ready to go. I just don't. I'm just quite concerned with this bill. Quite honestly, I don't see it. I don't see it moving forward as it is. So I just want to say thanks for your testimony.
Thank you.
Proceed.
Thanks for the interruptions. I'm sorry, I was worried that I was going to miss something as you were moving along. I want to just say, I think that one of the things that I have heard from this General Assembly again and again is that everybody who's eligible for benefits should receive them and nobody who isn't. And to the extent that the bill sponsor is trying to make sure nobody who isn't, I really laud those efforts and appreciate his efforts. I am really shocked at the amount of money that we're going to be spending on implementing some of these provisions, considering they may be going away. And so I share the concern about codifying those. I think we have a little bit of a whiplash right now in American government. Our Congress has really ceded its authority to the bureaucratic state, and so the rulemaking authority changes wildly depending on who is the president, and the states are left really playing catch up on that. We as a body have implemented a number of procedures to try to help make sure that all of those who can receive benefits can and those who shouldn't don't. But I would just like to echo the senator's comments that I don't see how this current form has any path forward on the floor of the Senate. I think that the senator from the 24th has shown her ability with her. I make a statement when people come by that we have one of the last standing filibusters, which means as long as any senator has lungs or legs will allow, they can block anything. And Senator from the 24th has certainly shown strong legs and strong lungs and her ability to block things. And I would be joining her in that effort in its current form. I just don't see a path forward. We need to make sure that only citizens, as the current law allows, receive benefits. But Representative, I don't know that you have the votes to get this out of committee, and it certainly doesn't have a path on the floor in this sentence. Even just saying the adults who live in the household can't share in the eligibility. It's like, well, okay, are they allowed to eat the food off of the plate after the kid was served it? I mean, it just totally disregards the way in which people are living their lives and puts an administrative burden on the state that's untenable. And so, anyways, that's not a question, Christine, as much as just to say thanks for answering those questions because you're technical. We went to college together, so that you've been doing this for 20 years is alarming to me. But I'm deeply, deeply concerned, and I don't think that we'll see any movement on this bill this session.
Further questions for the witness? Hearing none. Next witness in opposition.
Chair, members of the committee, Jessica Petrie-Telemaque here for Feeding Missouri and the Reach Healthcare Foundation. We really appreciate the representative's emphasis on program integrity, but have some real concerns about unintended consequences with this language. To Senator Coleman's point, the idea that families are going to have to prove their parenting and their financial responsibility for each application could result in eligible families who we want to help them put food on the table suddenly becoming ineligible. And those sorts of administrative barriers are real for Missourians. So from the food bank's perspective, we're already seeing heightened demand for food, and we have less supply. And so, if eligible individuals aren't having SNAP, we can't pick up the slack, and that means families are going to go hungry. The other thing I want to emphasize is there was some discussion about mirroring the approved food definitions on the Healthy SNAP waiver. That is also very concerning. I've had the pleasure of listening to two, multi-hour webinars where stakeholders are discussing these definitions and trying to figure out how you define candy and soda and prepared desserts is difficult, right? You want to ban Bit of honey candy, but you don't want to ban Honey Nut Cheerios. And turns out that is easier said than done. And so if we codify those definitions as we fine tune them over time, you all will have to update those, and it's going to be very difficult to administer. So happy to take any questions, but appreciate your time.
Questions for this witness? Hearing none. Next witness in opposition.
Could I snag a witness form? I'm a bad witness. Thank you.
One more.
Good afternoon, Katie Gamble here on behalf of the Missouri Beverage Association, going on record in opposition to the language. Thanks. I love going after Jessica because she does such an eloquent job of speaking. It leaves little for me to have to do. Specifically on the waiver portion of the bill, I was just going to give a little bit of background. I know it's been discussed. The department currently has a waiver that's already approved. So they submitted a waiver request in the fall. It was approved at the end of the year, and they're currently working towards implementation. And so just concerns about putting this in statute and what that means for the current waiver. And any complication that would have, especially waivers are pilot projects, they're 3-year programs with the intent of figuring out, hey, the goals that we set out to reach, are we reaching them with the way that the waiver is currently structured? How do we want to move forward? And so when you put it in statute, the department is required to have a waiver. What does that mean when we hit the end of the current one we're under? In regards to definitions, Jessica did a great job talking about that. I feel like I've been living my whole life in these definitions for over a year now, and it gets really complicated. A good example is, the waiver, I think within a week maybe of the initial waiver submission, there were updates to the beverage definition because we wanted to make sure that, people had access to hydration beverages. And there's been a lot of discussion, how do you describe candy without describing granola bars? We have prepared desserts are in our current, in the current waiver. How do you describe those items? It's become very complicated, and we're working on them. And so I would also have a lot of hesitation with putting very specific definitions in the legislation, just because we're still very much working through figuring that out. And I want to say the department's done a great job of working with all stakeholders, whether those are individuals using or that are on the program, whether those are grocery stores, the beverage industry, different, feeding organizations. They've really done a great job of pulling these stakeholders together in these very long calls, as Jessica mentioned. So they've been very engaging on that front. I would like to just say that in public.
Questions for this witness? Hearing none. Next witness in
Thank you.
opposition.
Good afternoon, Robin Shelp, Director of Policy and Advocacy for Kids Win Missouri. I want to go on record that we are against this bill. We have some concerns. I appreciate the sponsor for chatting with me a couple times about this bill. I think it's all been said for the most part. I just reiterate the concerns that Senator Coleman has, that this creates barriers to accessing food and health care for children who are U.S. residents and Missouri citizens. So that'll leave that there.
Questions for this witness? Hearing none. Next witness in opposition.
Mr. Chair, members of the committee, my name is Jay Hardenbrook. I'm the Advocacy Director for AARP here in the state of Missouri. We have a membership of just over 750,000 members here in the state of Missouri alone. I also, on behalf of the Missouri Budget Project, am submitting some legal analysis done by Legal Services of Eastern Missouri. They do more of these social service cases than anyone else, and so they've done an analysis of the legislation. I will say, I would add to everything that everyone else said, that it really is difficult when you're in the middle of implementing something like a waiver, a new program, when the General Assembly tries to add more requirements in the middle of that process. Again, I won't, just like anyone else, I won't speak for the department, but it can make it very difficult to do implementation when you all start changing the rules in the middle of that game. So again, similar as I've said to other things, wait until it's actually implemented, see if you like the way that they did it, and then you can come in and try to make changes. But please trust your departments to try to implement this in the first place, see how they do it, and then you can come back and do your critiques.
Questions for this witness? Hearing none.
Thank you so much.
Next witness in opposition. Seeing none, witnesses here testify for informational purposes only. Please proceed.
Mr. Chairman, good afternoon. My name is Ron Leone. I am the Executive Director for the Missouri Petroleum and Convenience Association, which means I represent many of your constituents who own, operate, or supply gas stations, convenience stores, and truck stops. We do not have a comment on the eligibility portion of the bill, Mr. Chairman. Immigration status, that's something we can all talk about maybe over a beer, but we certainly don't have any public testimony on that. I want to focus on the last section dealing with what products can and can't be purchased with the SNAP benefits. You've heard from several other people testifying in opposition that we have been granted a waiver. The state has already been granted a waiver. The Department of Social Services is in the process of implementing that waiver. What do we do in the real world with that? My members are looking for that guidance. We are participating in those interactive webinars that are taking place regularly, have been and will continue. I think the process is scheduled to be done by October. So it's premature to do that last section just because it will have to be changed. We're waiting to see what the department is attempting to do. My hope is that the department will provide a list of products that we can and can't sell versus just definitions that we have to apply. So we have to look at every product and decide whether or not it fits the definition. That would be an absolute nightmare, and there'd be no uniformity across the state. So as we're involved in those interactive webinars, we're encouraging the department to put out a list of what can be purchased with the SNAP benefits, maybe leave it up to the producers to provide that information and say that they comply with the definitions that they set up. So it's a little premature to do that. I'm happy to answer any questions. I appreciate the opportunity.
Questions for this witness? Yes, proceed.
I'm just so there's a possibility. So would this happen on the back end where when the scan happens with that code, it would be rejected, and so like there's a possibility that each of your members would have to program in things that would and would not be allowed?
Absolutely,
Okay.
absolutely. And again, we're asking for a list because there has been some discussion, and other states have done it poorly. Some states have done it well, and to Missouri's credit, they're kind of looking at all the different states before they come out and fully implement the waiver that's already been granted. But again, we need a list.
Yeah.
I mean, this has to happen quickly in thousands of locations across the state on a daily basis. So to have a list that's maybe, put into the computer, put into the scan is the only way it makes sense.
Yeah.
Definitions are not going to work for us.
I get that. I also, have, obviously I live in St. Louis County, but go through a lot of rural Missouri to get to our farm. It seems to me that some of your members are the only people providing any source of calories, food, for miles and miles around. So I'm also really sensitive to what that would look like for someone that, can't get to the nearest town where there's a grocery store or whatever. So
That's true, Senator. We're often the only game in town. You hear about
Yeah.
food deserts and things like that, and we do what we can. And it's funny, as we were talking here, as I was listening to some of the testimony, I know Congress, I don't know how it turned out, but Congress was looking at a hot food waiver that would be
Right.
allowed under SNAP, and that just happened this week, and I don't know if that happened or not. And so those are the kind of things that are constantly changing, and we want to be flexible, and putting something in statute is just not going to make sense for those of us that have to implement
Yes.
it in the real world.
Yep, very good. Thank you.
Thank you.
Further questions for this witness? Hearing none. Any further witnesses to testify for informational purposes? Seeing none. Representative, do you have any closing remarks?
Thank you. Of course, I did realize there would be this kind of opposition. We knew that there would be an uphill battle, but this is good policy. Regardless of the administration that this type of language will be passed down from, this is good policy. It's good stewardship for the state of Missouri. Taking it from a gentleman who grew up in the SNAP program, I've seen what the SNAP program is like. Take it from a gentleman who has been in the SNAP program as an adult. I have seen what it's like as an adult as well. The SNAP program does have its downfalls. It does have its errors. It does have its problems. And the state of Missouri does have its obligation to be a good steward of that program. This is good policy. I do challenge many of the things that were mentioned in the opposition. And I do challenge that for the next coming year, if this does not come out this year and we refile this next year. I thank the committee very much. Thank you.
Thank you. That will conclude the public hearing on House Bill 2481. And we now proceed to public hearing on House Bill 2927. Senator Coleman, would you take over the gavel for a moment, and I will present this bill.
Thank you, Mr. Chairman. Proceed when ready.
Thank you, Madam Chair, members of the committee. Curtis Trent, representing Senate District 20. The bill before the committee is House Bill 2927. This is the time-limited demand bill, which very simply says that when extra contractual damages are alleged, prior to them being alleged, a demand must be made in writing in reference to this section, submitted via certified mail with 90 days for the insurer to accept, and must contain the material terms specified in Section 2, which is, I believe, already essentially part of the law. There are some technical changes made from changing out the term time-limited demand to settlement demand for the purposes of this bill. But very briefly, what we're trying to do here is make sure that when these demands are made to an insurer for extra contractual damages, that everyone involved has time to consider the allegations that have been made, have time to investigate the claim, and have time to settle that before proceeding to litigation. Litigation, of course, very expensive. The threat thereof raises the cost of settlement, and ultimately all those costs get passed on to the end consumer. All of our constituents see these costs in higher premiums that they pay for insurance. So with that, I'd be happy to answer any questions the committee has.
Any questions for the bill handler's designee? Seeing none, first witness in support, please come forward. Can I just get a show of hands? We're running up on time. Can you raise your hand if you're in favor? Anyone here in opposition? Okay, can we try to limit our testimony? Just try to be concise. We won't do a timer. Okay, I'm being told by the secretary we're going to limit it to 2 minutes. Go ahead, please.
Good afternoon. Dana Fries, President CEO of Healthcare Services Group in Jefferson City. We're a member-owned insurance organization that insures 62 not-for-profit hospitals in Missouri and more than 2,000 physicians. We provide both professional and general liability insurance for healthcare providers throughout the state of Missouri. Testifying today on behalf of the Missouri Organization of Defense Lawyers and the Missouri Hospital Association. Section 537058, when adopted in 2017, was intended to afford liability insurance companies a fair and consistent opportunity to investigate, analyze, and settle claims. The statute, as originally adopted, provided that 90 days was deemed a reasonable amount of time, provided the information set forth in the statute was provided to the insurer. A time-limited settlement demand that was not open for at least 90 days could not be used against the insurer as evidence of bad faith to the extent someone wanted to pursue recovery against the insurance company above the policy limit for what is known as extra-contractual damages. Unfortunately, plaintiff attorneys have circumvented the original intent of Section 537058 by not asserting a time-limited settlement demand. They instead make a settlement demand which is kept open for a much shorter time or a vague amount of time, such as a commercially reasonable amount of time, and then withdraw the demand without prior notice and claim the insurance company acted in bad faith. House Bill 2927 simply remedies the problem by removing reference to time limited and inserting in lieu thereof settlement demand. In other words, 2927 provides that for a settlement demand to be used as the basis to assert a bad faith claim, the prior settlement demand must have been kept open for at least 90 days from the date the settlement demand was received by the insurer. I deal directly as CEO with reinsurers and with our rating actuaries, and I will tell you each and every year they ask me about bad faith claims and the bad faith environment in Missouri. It does impact the rates that we all pay for liability insurance. We're not trying to change the policy here. We're simply closing the loophole and reinforcing the policy that was adopted in 2017. Nothing more, nothing less. 90 days is a reasonable amount of time. That was the period of time that was adopted in 2017. The roots of that go back to the prejudgment interest statute in the state of Missouri. So it's a reasonable amount of time. To give you one recent example of the gamesmanship the plaintiff attorneys use in the state of Missouri to circumvent the 2017 law is the recent case of Escabusa v. Safe Auto Insurance Company. In that particular case...
Do you mind wrapping up your testimony, please?
Sure. So the point is, in that particular case, the insurance company offered the settlement to settle for the policy limits 9 different times to 4 different... That's all we're trying to do here is to close the loophole.
Any questions for this witness? Thank you for your testimony.
Thank you.
Next witness in support, please come forward.
Thank you, sir.
Good afternoon, Madam Chairwoman. Hampton Williams with the Missouri Insurance Coalition, testifying in support of this bill. APCIA has estimated that the loophole that's been left in this 2017 reform is costing Missouri households nearly $3,400 a year, nearly $2 billion to the state in direct costs, and impacting 32,000 jobs in this state. This is, when I speak with my members, one of the most important issues that we hear, that they're looking that this law be applied evenly across practitioners. All we're asking is that the intent of the legislature from 2017 be applied to all settlement demands, and for our folks to be given a reasonable opportunity to evaluate the claim. It does not require us to wait until 90 days to settle a claim. It only requires us the opportunity to review a demand before making a determination about that. Happy to answer any questions.
Any questions for the witness? Thank you for your
Thank you for your
testimony.
time.
Next in support.
Madam Chair, member of the committee, and Bruce, Ray McCarty, Associated Industries of Missouri, want to go on record in support of this bill as we did the previous Senate bill. Happy to answer any questions.
Thank you for your brief testimony. Any questions for this very concise testimony? Next in support.
Good afternoon, Madam Chair, members of the committee. Philip Arnzen with the National Association of Mutual Insurance Companies, known as NAMIC. We got to go on the record in support. The previous witnesses did a good job of explaining what our position is. This would help put downward pressure on rates, and this issue is a priority for NAMIC's members that operate in Missouri.
Thank you for your testimony. Any questions? Thank you. Next in support.
Madam Chairman, members of the committee, Rich Aubuchon here on behalf of the Missouri Civil Justice Reform Coalition and the American Property Casualty Insurance Association in support of the bill.
Thank you for your testimony. Any questions for this witness? Seeing none. Anyone else here in support? Seeing, oh, you did? Oh, I have a question. Anyone else in support? Seeing none. Anyone here in opposition? First witness, please come forward.
Thank you very much, Madam Vice Chairwoman, members of the committee. My name is Arnie C. A.C. Dienoff. I submitted my online testimony in opposition on the portal. Appreciate that. I'm opposed to HB 2927 and SB 1120, which I testified earlier a few months ago in the Senate committee. A settlement is an order if negotiated and agreed to by parties, and it can happen before the end of trial. This can be done voluntarily. Putting a 90-day demand letter is unnecessary. This is driven by the Insurance Coalition and insurance lobbyists. This bill is just another barrier, another law solely to prohibit, solely for profits of the insurance industry and defense lawyers. This is not a good consumer protection bill for Missourians. Missourians come first over any insurance coalition lobbyist. Therefore, I cannot support this bill or the Senate bill. Thank you, Madam Vice Chairwoman.
Thank you so much for your testimony. Any questions for this witness? Seeing none. Please come forward.
Good afternoon. My name is Craig Ortworth. I'm a member of the Executive Committee of the Missouri Association of Trial Attorneys, also a practicing attorney who specializes in this area. I represent families and individuals who injured in car accidents and wrongful death. In my practice, settlement demands are not gamesmanship. That's how cases get resolved. I'd like to very briefly talk a little bit about the case that was referenced earlier. The system worked. The appellate court agreed that they didn't have a reasonable time. So I don't know if we need a statute when there are already things in place, Missouri bad faith law, to prevent this very thing. 2927 settlement demands make essentially worthless these settlement demands unless by certified mail, includes extensive medical and employment authorization, and remain open for 90 days. Again, unlike what was said earlier, if it's not left open for 90 days, it cannot be used later. They talk a lot about extra contractual damages, okay? Those only come about when a judge or a jury has awarded those. These aren't made up by plaintiffs' lawyers. These aren't made up by the parties. These are actually done through litigation. When a case should have been settled for the policy limits and wasn't, extra contractual damages arise. This helps the parties, particularly the plaintiffs, help collect those. Second thing, the bad faith claim that we talked about isn't owned by my clients, isn't owned by the injured party. It's owned by the insureds. This bill takes away any teeth that those insureds have to have their insurance companies act in good faith and in their best interest. This bill will make it harder for injured Missourians to resolve claims. Will expose the insureds, your constituents, my fellow Missourians, to greater excess judgments and greater worry. The last thing I'd like to say is, year after year, the insurance lobby asks for changes to insurance laws and to tort reform. And year after year, they get some of those changes. But year after year, my premiums go up. Right? I'm a small business owner. I have employees. I have work comp insurance, commercial general lines, auto on my cars and on my building. Right? Never once have my premiums gone down. Year after year, these changes happen, and year after year, we see premiums go up, even though we're promised savings, and we simply don't. Okay? We don't see them. For those reasons, and of course many more, we urge you to vote no against this bill.
Any questions for this witness? Is there any product you found that prices have gone down on?
I'm sorry?
Is there anything that prices have gone down on? Have you found one? I don't know. I just was wondering.
I suppose not.
A little flippant, forgive me. I appreciate your testimony.
But I also don't recall Schnucks promising me the bills would go down. I do recall the insurance lobby promising lots of would help us.
I have not heard that in my 8 years, but I appreciate your testimony. Thank you for being here. Anyone here to testify in opposition? Anyone here for informational purposes? Senator, any concluding remarks on behalf of the representative?
I would just add that there has been comprehensive tort reform packages gone through in other states, particularly Florida, and they have seen significant decreases in premiums. So perhaps the problem is that we just haven't had enough tort reform here in Missouri. I appreciate the committee's time and consideration of this bill.
Thank you. With that, I'd like to end the hearing for the Senate's General Laws Committee. Do I have a second? All in favor?